please confirm appearance.
Dennis Levitt, Your Honor, 3757, present with Tara Kellogg.
Alex Ghibaudo, proper person, Your Honor. Alright, have a seat.
Right. Court issued a show cause. This matter is set to determine whether or not we're going to have an indirect civil contempt proceeding. Mr. Levitt, you filed a proceeding saying that payments were not being made timely each month. Is that right?
Yeah, when we were here before, you told me to file an affidavit of...
I understand. I'm just trying to see whether there's been any change.
None.
The $2,500 payment made due in January, was it made?
No.
Was the $2,500 payment due in February, was it made?
No.
Was the $2,500 payment due in March made?
No.
Okay. Mr. Ghibaudo, I received a filing from you yesterday. Did you serve that on Mr. Levitt?
I did, Your Honor.
All right, look, you're bringing a bunch of noise that I'm not interested in. I don't care about any of these. When I say I don't care about them, we are not going to have a contempt proceeding on indirect civil contempt concerning how you communicate, who you provide context to, or any of that nonsense. This court has held a cavalcade of hearings during the course of the last 4 months ad nauseum that I'm going to walk through when we have this hearing to get you to pay on a specific time. And whether you're held in contempt and whether you're sanctioned for that contempt will depend on your payment history, okay? We have a clear order. We have notice to you. This is we have had many notices that the court was considering indirect civil contempt to compel compliance. And the only thing that is left is whether or not the court would issue specific orders either for monetary sanctions or incarceration to include coerced contempt. Now, I'm required to have a hearing at a time that you're aware of. You should get counsel. If you don't have counsel, you are an attorney, so I expect you to know. This is not criminal contempt. They will present their prima facie case. They'll show that the court has jurisdiction with the affidavit. They will have the testimony of the plaintiff. They will provide the notice information concerning the specific orders, and you'll have an opportunity to be heard. The willful failure to perform an ordered obligation, as simple as paying X amount of dollars every month, is the specific allegation that I'm going to deal with. And I'm very sad and disgusted to be at this point with you, okay? There'll be another time and place, I guess, if you guys continue to have problems related to these other non-specific disputes. The other thing I want to mention is that, I inherited this nonsense, but you guys are under this assumption that this case is sealed. Judge Kent or whatever said something in a journal entry years ago to seal this case pursuant to 125-110. There's no other order in the whole case that seals this case, okay? So if you want to do one, then somebody should get off there, and do one. And only to the extent of 125-110, which protects pleadings, service documents in some instances, and judgments, okay? This case isn't even sealed now, okay? As far as the issue of contempt, the best defense for you is to show that you've paid, and they say you haven't. So I'm going to give you a minute or two because I'm not interested in hearing your defense today. I'm going to hear it at the appointed time, but I want to know why, is it possible that you failed to make the minimum payment timely for the last 3 months?
I can't pay it, Your Honor. I have here a document that shows where my bank account is now. I just came off of a lien that was placed on my accounts for $7,800.
Who placed the lien on the account?
The people that I tried to get a loan, that I did get a loan from to pay her last time because I can't afford to pay her. I also have what the court asked me before, a profit and loss statement for all 2017, showing what the income was and what the expenses are. The court wants to see it, I have it here.
Have you provided them to Mr. Levitt?
I did, Your Honor.
All right. Did you get any offers of proof concerning his assets?
No, Judge, I served discovery and he refused to answer.
Because
what's in your hand?
What he asked for
What's in your hand?
What's in my hand is...
Is that what you say you gave him?
Today, yes, Your Honor.
When?
Today.
When?
Before court.
Before court.
Did you get it or not?
Yeah, I looked at it. It's just some
It's 2
typed up
pages.
thing. It's
All right,
nothing.
that's fine.
It's not typed up.
The
now.
Alright, well, first of all, it's your burden. I mean, all you gotta do is show that you haven't paid, and it's your burden to show that you have a defense, okay? This is a serious matter, we're done. I looked at the history of this case as I walked through the procedural posture, and I'm like, what am I doing? You'll have an opportunity to be heard and present information to the court. If it's persuasive, then I'll consider it as a defense. If not, you're gonna be found in contempt, okay? And, I guess, Mr. Levitt, I mean, do you want any time to evaluate his finances before you put on your case for contempt?
No, he's not gonna cooperate.
All right.
Very
That's not the
clear. He
case here.
refuses to
Your Honor,
cooperate.
here's the problem. I asked if you read the pleadings, and I know you didn't have time because I've been dealing with a litigation I got dragged into because she decided to get involved with some guy that decided to target me for the last 6 months. That has actually dropped my revenue. She added 73 people to a web page that has been doing nothing but targeting me for the last 6 months.
Well, this is the kind of stuff that you would take an oath and you would testify and
I will
provide
testify
information.
to, Your
Well,
Honor.
we need to get there, because I'm sick and tired of having these offers of proof at these hearings where I give you every benefit of the doubt. You're gonna need to provide sufficient proof or you're gonna be held in contempt, okay? Your defense that you cannot pay is a factual issue that I have to evaluate. You haven't taken an oath, I'm not interested in hearing it today, I'll hear it at an appointed time. Mr. Levitt, do you think that you can put this case on in an hour?
Yes.
All right. We'll be here on the 19th, that's Monday at 1:30. And is there any of the documentation that you're talking about that has not been delivered to Mr. Levitt?
Here's what happened, Your Honor. He submitted, I asked him, I told him, I informed them, this has been 30 days you've had to do discovery. I'm not giving it to you at this point because guess what, you're late. It's been 30 days. You have 30 days to do it.
We don't need an order, we don't need notice, we already have all that already. We have an affidavit, we have a testimony of the plaintiff.
But let me finish, Your Honor. Then, 10 minutes later, he shoots me interrogatories, request for production and such, asking for discovery going back to January 1st, 2015.
I know, but
This is
that's
not
problematic. Forget it. That's a red herring. We have my orders that have been tracking for the last. What they're actually requesting is a lot more than what I've ordered you to do to stay out of contempt. Their claims exceed even the minimum payment that we've been talking about. Okay, you need to appear. If you don't appear, benchmark's going to be issued for your arrest. Okay. You need to appear, you need to answer his questions, you need to take an oath, and you need to offer your testimony and other evidence that would show that there's an excuse for your failure to pay what you've been ordered to pay. And the court will render its judgment based on the sufficiency of the proof, okay? And if you provide sufficient proof that would mitigate a finding of contempt, then I'll make that finding. If you don't, you should be held in contempt.
And lose my license, and then exactly what they want,
It is.
They get it.
Well, whatever. I mean, the fact of the matter is that I have managed this case with hearings about every month, okay, and done everything that the court should do to give you an opportunity to comply.
And I have. Thank you for laughing, counsel.
Well,
Very professional.
Since January, I asked you, what have you paid her?
Since January, Your Honor, I paid her $12,000 in 2 months, from November to December. $12,000. It put me in a hole.
Wow.
I had to pay $4,000 by February 1st just to cover rent. I was behind on my rent. I was behind on the rent at the office. I was behind on. There's still invoices that are outstanding. I'm gonna pay because I'm paying her. She's a black hole.
Okay.
She does nothing. She's not even trying to go to school at this point.
But see, you're gonna get lost. That's gonna defeat you. If you're attacking her when your focus has got to be on fulfilling your financial obligations or providing sufficient proof that would explain why you're not.
Why can't the
Can I say
focus
one
also
thing?
be on their clean hand, whether she has clean hands walking into this court trying to hold me in contempt? She's asking the court for to invoke its equitable powers, and she's doing everything she can to undermine me.
It's not true.
That is an absolute absurdity.
Well,
I have to stand here and defend myself with all the stuff that she's doing, trying to bar complaints, getting online with these clowns that are trying to destroy my reputation, and then I have to answer to this and get held in contempt.
You have to answer to it. You have to answer to it because you've proven nothing. The hearing of this is when you get a chance to make your case. Okay, just because you say it doesn't mean it's true, and you of all people should know better than that.
I get that, Your Honor,
Okay.
but it's
So present your evidence. If you show that a person who is seeking to have you held in contempt is contributing to the inability to comply with the orders, then that might have some weight with the court as to whether or not that's why you have a right to be heard. You have to have a willful failure to perform. Okay, if you have the ability to perform and you're willfully not performing because you think that she's a black hole or whatever the heck you said, then you're going to be held in contempt. Because that is not a valid position to take on these orders. Okay? It doesn't matter what you think about her. You comply with the orders. Now, if you could show me that your failure to perform is because of an inability, that might be an equitable defense. All right? Mr. Levitt, you have filed a jurisdictional affidavit. You have served him with the order to show cause. We have written order related to what he's supposed to do. Are there any other elements of this that you got any issues with?
No, well, Judge, I'm getting sick of being dragged into this. All I'm trying to do is enforce orders. Your orders are no good unless they're going to be enforced.
I understand that, but
He tells me to sit down. He tries to make a war with me when all I'm doing is trying to enforce orders. You heard it. He brought all this other stuff in. All this is about is, did he pay? No.
Well, no,
period.
it's not. That's not what it's all about. And you will be responsible in the form of arguing this matter based on what your client has or hasn't done. Okay?
He's got some war going on with Mark and Mercedes.
I have no idea what you're talking about, but I'll find out about it on Monday. Okay?
And
On Monday, we'll have a hearing. We'll have a hearing related to the order show cause. It'll be 1:30. I got an hour for it. Okay? You will call your client. You can ask questions of Mr. Ghibaudo, and Mr. Ghibaudo, you'll be able to offer your testimony and evidence, finally to be able to have some evidence to support what you're representing to the court. Okay? All right. We'll see you on Monday, the 19th at 1:30.
Your Honor, I do have a counter motion. I don't even know how to address it because it was an affidavit that was submitted. It wasn't even an affidavit that was signed by her as her attorney. I understand this court ordered it, but it's still inappropriate for an order to show cause. That said, it was a motion to terminate or modify alimony and for custody issues. And I do need to have her sanctioned.
You filed this yesterday.
Well, let's get a date on it, let them get a date on it, put a date on it, and let's let them oppose it, Your Honor. I need to have that heard because I can't afford to pay her.
Well, whatever. You have you know the answer to the question. You want a motion for relief, you have to notice it, you have to give them an opportunity to be heard, and it has nothing to do with the contempt proceedings. Contempt proceedings are what is the order, what have you done, and do you have a defense? That's it. We'll deal with the other issues as is. This motion or this reply and counter motion that was filed yesterday needs to be set for hearing, needs to be served on Mr. Levin, and will be considered separate from the contempt proceedings. Okay? It's not a defense to contempt to say that you have some valid motion to modify.
No, it's not, but I figured if we're gonna have a hearing, I didn't know it was gonna be held.
No. We're having a narrow hearing on the issue of payment. We're not having a hearing concerning what the context of your text messages are. We're not gonna have a hearing related to this nonsense about what you do with your assets. Okay? They can offer evidence in the form of testimony to contradict your assertions related to your financial circumstances. You are under a clear order to pay a certain amount by a certain time, and since you haven't done it, you're gonna make a case for contempt, and the court is going to determine whether there's indirect civil contempt here. Okay, and then that will be a closed issue, and then all the other issues we'll deal with it when and if we have to. Okay, we talked about this the first week in January about whether or not there needed to be some sort of request for relief. So it dawned on you to file papers yesterday?
No, but I've been busy, a little bit busy trying to stay afloat. And trying to deal with the Chiro idiot that this woman brought into my life because she's a hostile human being. That's what I've been doing. I filed 5 motions in a row to try to get rid of this guy in a case where he sued me. He sued me. And I had to get rid of it. Finally got him to get rid of it. Guess what? Then he finally said, yeah, she dragged me into this. Yeah, she wanted me to post all the stuff about it.
Again, it's not constructive
And she smiles, she thinks it's funny.
Look, focus on the issue here, okay? The issue here is whether or not there should be a finding of indirect civil contempt for the non-payment of support. That's it. And the matter will be considered at 1:30 on the